We have some major breaking news out of the United States Supreme Court. The United States Department of Justice, through the Solicitor General John Sauer, has filed a major brief in a case called Jaman Rush versus the United States involving supposedly sort of the constitutionality of the National Firearms Act, specific to short barrel rifles. Well, there's been some kerfluffle online about whether or not this brief was a terrible idea to be submitted by the DOJ or not, and I want to break down what it all means. The bottom line is the DOJ's ultimate conclusion is okie dokie with us, but sort of some of the methodological arguments they made, not so smoothy poothy. Let's break it down when we come right back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, folks, so we have to break down this submission to the United States Supreme Court by the Donald Trump Bondi Solicitor General's office, submitted by the SG John Sauer, in this case of Jaman Rush versus the United States. And I want to break this down. I don't want you to lose a lot of sleep about what I'm going to say here, because it's not going to matter in the grand scheme of things. So I don't want you to dwell on what I'm about to say here. But there are some important takeaways here that we're going to want to pay attention to moving forward. So again, don't stress out about this case. They're not going to grant cert in this case. It's just not the right vehicle for a lot of reasons, which you'll see in 1 minute. Specifically, the Rush case here, where a lot of people are commenting on X about terrible arguments made by the Department of Justice, and we'll get to those in a moment. This Rush case involves frankly, what appears to be sort of a career kind of criminal guy with kind of a bad record. And this guy was arrested with an unregistered short barrel rifle and sentenced to 30 months in prison. Well, it gets a little bit nastier than that. And why I say that is, if you look at the fact pattern here, remember my rule, we want to go to the United States Supreme Court and have the U.S. Supreme Court hear cases where the Second Amendment rights claimant, the Second Amendment plaintiff, is really a choir boy, right? Is a Boy Scout, is a Dick Heller with a perfect record, no criminal problems, and so on. We do not want to be taking Second Amendment related cases to the U.S. Supreme Court on bad facts, like we saw with Zacky Rahimi, where we got out of that case okay with the final holding, but it was not a good vehicle, which is why Biden Attorney General Merrick Garland shoved to the front of the line of all the Second Amendment issues in America. Merrick Garland shoved to the front of the line to the Supreme Court the Zacky Rahimi case, because Mr. Rahimi was an obvious criminal bad dude who had taken his girlfriend's head and bashed it against the dashboard and then shot at witnesses and engaged in other multiple shootings and had admitted to being violent on the record at a court hearing. Not a good fact pattern, not sympathetic. This Supreme Court, remember, does not like criminals. So we don't want to go to the U.S. Supreme Court in cases involving criminals. We want to go to the Supreme Court in cases involving good people, law-abiding people who don't have a criminal record. So with that said, this particular case is Jaman Rush. Mr. Rush, according to the record, was caught by a police officer, ready for this, driving a motor vehicle to a court appearance where he was appearing for, believe it or not, driving without a license or on a suspended license. To make matters worse, he had had his license revoked. And despite having his license revoked, he drove to his hearing and was seen by police. Then he drove away from the hearing home, and the police stopped him to discuss why are you driving without a license? Your license has been revoked, at which point they smelled marijuana and saw marijuana in the car. The police then tried to address this, and Mr. Rush, according to the record, ran away and was then basically stopped after a kind of a fisticuff situation, a back and forth situation. He was then restrained, and then they searched his car and found illegal firearms, i.e. a short barrel rifle that had not been registered on the National Firearms Act. This is not the guy we want to represent the Second Amendment in the Supreme Court. And yet it is Jaman Rush, this exact guy, who is seeking cert to argue that short barrel rifles are protected arms under the Second Amendment, and he should have not gone to prison for possession of this firearm. Now again, regardless of what we think about the good and the bad and the ugly of the legal arguments here, Jaman Rush is not the person we want going to the Supreme Court on our behalf in the Second Amendment community. Hello, this is not rocket science. So now, that is the big picture here. The Solicitor General's office and the Trump administration are not dumb on these kinds of issues. They know as well they don't want this kind of a case to be before the Supreme Court on a Second Amendment question, because we're going to get bad law on the Second Amendment. And this administration, as a general matter, does not want that. So what happened is, with that context, Mr. Rush was convicted of possessing a short barrel rifle in violation of the National Firearms Act. And then he, raised Second Amendment defense in the district court in the Southern District of Illinois. It was denied. His motion was denied. He was convicted. He appealed to the U.S. Court of Appeals for the Seventh Circuit, and they said no. Under the Miller case in 1939, the Supreme Court said short barrel shotguns are not protected arms. A short barrel rifle is analogous to a short barrel shotgun, and therefore this is not a protected arm. And the Seventh Circuit Court of Appeals rejected his attempt to overturn his conviction, and now he's seeking cert on Second Amendment grounds to the U.S. Supreme Court. So the Department of Justice has just filed a brief opposing the petition for cert by Jaman Rush here. This is 100% correct. The Bondi Trump Department of Justice in opposing cert of Jaman Rush's cert petition is correct. We want cert denied in this case. It is not a good vehicle for the Supreme Court to take. And as I've explained to you before, the Supreme Court is only going to take a couple of Second Amendment cases a year at most. So why on earth in the Second Amendment community do we want a criminal like this representing our community in front of the Supreme Court? We do not. And that is exactly what the Trump Bondi Department of Justice agrees with. And that is why they are seeking to deny cert, which is correct. Now, with that said, there's a lot of anger online by certain people in the Second Amendment community that are upset with some of the arguments made by the Department of Justice in this brief. So what I'm going to do first here, make it clear, is I'm going to point out the correct arguments made by DOJ and applaud them for it. To say, yeah, this is right. This is a winning argument. No problem. The cert is going to be denied, and that is mission critical. And then I'm going to identify a couple arguments they advanced, which frankly are a little bit methodologically wrong, but no harm, no foul in this case, because there's like 0% chance that the Rush cert petition is going to be granted. So with that said, let me go to where the Department of Justice did a good job. Specifically, the first thing they did was they argued that cert should be denied on these bad facts. 100% right. That is 100% right. That's the most important thing, to say this case should not be granted cert. That is the most important position, the most important conclusion, and the Department of Justice got that right. Number two, the Department of Justice also did a good job flagging the issues presented by a case like this, dealing with whether or not an arm is protected under the Second Amendment. And relatedly, they did a good job pointing out that the best vehicle to address these particular issues, which I'll give you a rundown in 1 second, the best vehicle to address these issues about what kinds of arms are protected under the Second Amendment are AR-15 ban cases of the sort of thing we see in the Cheeseman Association in New Jersey Rifle and Pistol Club, right, out of New Jersey, Third Circuit, And, of course, the Barnett case out of the 7th Circuit in Chicago. So the Department of Justice got that right. They got the right conclusion cert should be denied. They got the right conclusion that there's several issues involving these kinds of questions of what arms should be protected can be clarified by the Supreme Court. And they also reached the right conclusion that the proper case vehicle for doing so is a question of whether or not one of these state-based AR-15 semi-automatic rifle ban cases, one of these bans are constitutional or not. Here's what the DOJ had to say on this very issue. The Department of Justice says, quote, "The petitioner here asks this court to grant cert to resolve a variety of analytical issues involving the Second Amendment, such as the meaning of the word arms in the Second Amendment, whether the Second Amendment protects arms that are in common use, how to determine whether an arm is in common use, whether the common use issue belongs in Bruin Step 1, plain text, or Bruin Step 2, history, and whether arms lose Second Amendment protection because the military may find them useful. The DOJ goes on to say, some of these questions that the petitioner, and that is Mr. Rush, raises may well warrant review in an appropriate case. See Snope versus Brown, statements of Kavanaugh, and a dissent from Thomas. But listen carefully, folks, this is mission critical. But this Rush case would be a poor vehicle for addressing these Second Amendment issues. He goes on to say that other types of cases, for example, cases involving state laws banning AR-15 rifles, would provide better vehicles for clarifying the appropriate framework for discerning what types of arms the Second Amendment protects. Exactly right. This is the lead, folks. The DOJ under Trump and Bondi correctly are arguing that the Rush case should be denied cert. That is what we want, folks. We want the Rush case denied cert. Do not kid yourself. Okay? On the Four Boxes Diner channel, we play in the real world, not in some fantasy land. This is not like an online video game with multiple players. We play in the real world. And we do not want this case granted cert because Mr. Rush is not a good person based on the record. But the good news is the DOJ also points out, as you just saw there, that they're pointing out to the Supreme Court that the best vehicle, the best case vehicle to decide some of these Second Amendment open questions, which frankly is not that open. I think Heller actually answered these questions, but that's a separate issue. But the point is, the Solicitor General is correctly saying that to the extent these issues need to be resolved, the best vehicle for addressing these questions about the Second Amendment is not Mr. Rush, the criminal guy here, who was arrested with illegal guns and marijuana and driving without a license and so on, sentenced to 30 months in prison. Got to work hard to get that outcome. No, the proper vehicle is deciding whether or not AR-15 bans in states like New Jersey and Illinois and California, whether or not they're constitutional or not under the Second Amendment. And as I've explained to you before, if the Supreme Court grants cert in one of those cases, we're going to win them. We're going to win that case. And the Solicitor General knows this. So the Solicitor General is correctly trying to kill this Rush case and get the Supreme Court to pick up an AR-15 case, which is the 100% correct strategy. I agree with completely. Now, with that said, there's a couple things here that the DOJ said in its brief that is not quite correct. It's okay they said it in the context of Rush because the Supreme Court's going to deny cert here. And frankly, I don't want to sort of say this in a derogatory way, but I think I'm basically kind of accurate. The Solicitor General's office is full of very smart lawyers, and they know what cases are real cases before the Supreme Court and might get granted cert, and which cases are highly unlikely to be so. This case was just not going to be granted cert in my view. The SG's office knows this. So I don't want to say that the Solicitor General's office with this brief sort of mailed it in. They just kind of like mouthed some basic words that maybe would not be so precise in a different context. But they know this case is not going to be granted cert, and I think they said enough to make sure that's not going to happen with no harm, no foul to the Second Amendment. But they still said a few things that in a different context, I would be a bit more aggressive in criticizing, but here I understand kind of why they do that. So the first example where I think they were kind of a little, I don't want to say sloppy, that's not right, but they just basically hung their hat completely on the fact that the U.S. versus Miller case in 1939 is like, totally applicable, binding case law. It is binding case law, but it kind of begs the question of whether or not a short barrel shotgun or a short barrel rifle is a protected arm under the Second Amendment, because really to analyze that, you have to apply the in common use test, and the DOJ brief does not sort of make that point. They just basically cite to U.S. versus Miller and say, well, see, the Supreme Court says you can ban short barrel shotguns. This is a short barrel rifle case involving Mr. Rush. That's sufficiently analogous, so, it's already been resolved. That's not really true, right? Because the in common use analysis has not been done with short barrel rifles or short barrel shotguns, so it's still technically kind of an open question. But that is one point that I think you could sort of make an observation. Well, maybe they were a little sleek in how they kind of did this. The other thing, of course, is that they quote this language from a dissent by Justice Alito in 2015 in a case called Johnson versus United States, which is actually a statutory case involving the Armed Career Criminal Act. And in this case, specifically what Justice Alito quotes, and I think this is perfectly fine to cite here, but really it's not super applicable to a Second Amendment case, but maybe it kind of is because it's Justice Alito. He's really an important justice, and he references Heller here. Here's what Justice Alito had to say in 2015 in a statutory case talking about sawed-off shotguns and sawed-off rifles. Under these principles, unlawful possession of a sawed-off shotgun qualifies as a violent felony. As we recognize in the District of Columbia versus Heller, sawed-off shotguns are not typically possessed by law-abiding citizens for lawful purposes. Instead, they are uniquely attracted to violent criminals. Much easier to conceal than long-barreled shotguns used for hunting and other lawful purposes, short-barreled shotguns can be hidden under a coat, tucked into a bag, or stored under a car seat. And like a handgun, they can be fired with one hand, except to more lethal effect. And I think it's fine to quote Justice Alito there, but again, it's a statutory case, not dealing specifically with the Second Amendment, although he does reference that. The other thing is, remember, when you analyze whether or not a firearm is a protected arm, you really are supposed to focus on the lawful uses of the arm. You're not supposed to focus on the unlawful uses of it. Just like when we protect the First Amendment right to free speech, we focus on the lawful uses of free speech. We don't focus on the misuse of speech, the fraud, the defamation, and the like. But here's what the DOJ had to say, really laser focused on the criminal misuse of short barrel rifles, which again is kind of the wrong perspective. Sawed-off shotguns were the weapon of choice for gangsters and bank robbers during the Prohibition era. Al Capone's South Side Chicago henchmen used sawed-off shotguns when they executed their rivals from Bugs Moran's North Side gang during the infamous St. Valentine's Day Massacre of 1929. So again, a focus on the criminal misuse of firearms is really not the right perspective. Under Heller, you're supposed to look at the lawful use of firearms. And finally, the Solicitor General points out that no lower court of appeals has found that a sawed-off shotgun or a sawed-off rifle is a protected arm under the Second Amendment, so there's no circuit split, which is correct. But as you know, for both Heller and Bruin, the coalescence of lower courts on a particular legal point involving the Second Amendment, frankly, is not that persuasive. The Supreme Court, at the end of the day, they don't care. They're going to make their own choice. But with that said, I think the DOJ brief here is good enough to make sure that the Rush case is denied cert. And from the Second Amendment community point of view, that's all we should care about. There are some other points that the DOJ made in this brief that we're probably going to have to clarify and improve upon. But no harm, no foul to this, because again, the ultimate thing is we cannot have criminal cases like this going up before the Supreme Court on the Second Amendment question, because it will come back and bite us on the dupa, and we do not want that to occur. And the SG doesn't want that to occur, which is why I'm perfectly fine for them to take whatever they need to do to kill this Rush case right now so it doesn't get to the Supreme Court. And when the AR-15 cases pop up there, it's pretty clear the SG is going to be on our side, and that is when the rubber's going to hit the road, and I suspect they will nail every point at that time. Okay, folks, there you have it. Hopefully you enjoyed today's episode. Make sure you follow me on X at 4 Boxes Diner, and don't forget to subscribe to YouTube and to Rumway. I look forward to talking again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.